Costner's accuser defends her lawsuit as court hearing nears. My belief is that Devyn LaBella's claims were designed, through the use of false statements and sensationalistic language, to damage my reputation, said filmmaker Kevin Costner, responding to a lawsuit filed against him by a stunt double on his film Horizon, an American Saga, Chapter 2. That statement was from an August 18th declaration filed by Costner, in which he counters the claims of a hostile work environment that were outlined in a lawsuit by LaBella, who was a stunt double on the 2023 production of the yet-to-be-released film. Costner added that he believes his accuser is an opportunist seeking a massive and unjustified payday, and he submitted his declaration with a request that the lawsuit be dismissed. In a new court filing submitted by LaBella on September 5th, she is doubling down on her allegations ahead of the September 18th court hearing, which will either see the case move forward or be dismissed. Now, she claims she is the victim of sexual harassment, which was allegedly facilitated by Costner. Reader discretion is advised. The following information and excerpts from the lawsuit are of a graphic and intimate nature. Since May, filmmaker Kevin Costner has been embroiled in a legal battle surrounding the production of Horizon, an American Saga, Chapter 2. LaBella, a stunt double on the film, filed a lawsuit against Costner, claiming that Costner created a hostile work environment when he allegedly forced her to perform in a violent, unscripted, unscheduled rape scene. Of this situation, LaBella's lawsuit states, "There was no escaping the situation, and all LaBella could do was wait for the nightmare to end." LaBella's account of the scene, which was filmed on May 2nd, 2023, was as follows. In his August 18th declaration, Costner writes, "When I reviewed the complaint filed by LaBella in this lawsuit, I was shocked at the false and misleading allegations she was making." LaBella's lawsuit goes on to claim her ability to work was impeded upon, saying she experienced continuous reminders of the shame, humiliation, and complete lack of control she had experienced during the May 2nd filming. She experienced sudden bouts of crying on and off set. When the film wrapped production, she was not hired to return for Horizon, an American Saga, Chapter 3. Costner noted that she would not be hired for the third film in the series as the character she had been the stunt double for in Chapter 2 does not return for the next film. In the latest court document filed on September 5th by LaBella, we learn that Costner's declaration for dismissal of the lawsuit is categorized as an anti-SLAPP measure. SLAPP is an acronym for Strategic Lawsuits Against Public Participation, and Costner's legal team is accusing LaBella and her lawsuit of seeking to intimidate and suppress Costner's freedom of speech as an artist. LaBella's response on September 5th takes the SLAPP accusation to task, stating it is without merit. The absence of the intimacy coordinator was not explained in Costner's declaration. Later, LaBella's latest court filing says, Costner and his legal team once again misstate the basis of LaBella's claim. It is not the blocking of a shot in a movie production that Ms. LaBella finds offensive. It was their blatant refusal to follow the safety protocols and procedures that are required. Costner's declaration detailed how the blocking, or choreographing, of the shot in question was accomplished, and Costner's account notes that the shot was only ever blocked but never filmed. This is one of the central areas of contradiction between LaBella and Costner. The day before the May 2nd, 2023, incident, Costner directed a scripted rape scene involving LaBella, and LaBella leans on this, stating, "The May 1st scene is the perfect example that the same creative product can be produced when the proper protocols are followed." LaBella's contracts, the filing states, require the presence of an intimacy coordinator for shots involving simulated sex acts, as well as written notice 48 hours before such a scene is to be shot, with LaBella adding. Costner and his legal team now argue that ignoring Ms. LaBella's rights for this scene is protected activity because it was part of the creative process. Continuing, LaBella says, when Costner and his legal team claim that the actual objective of Ms. LaBella's suit is to interfere with and burden Costner's exercise of free speech rights in connection with a creative work, they imply that in the name of creativity, they were free to violate any law or employee's contractual rights with complete impunity. The latest filing from LaBella ends by stating, in sum, the court should deny defendant's special motion to strike in its entirety. View LaBella's September 5th court filing, courtesy of Deadline. Here, responding to LaBella's newly submitted claims, Kevin Costner's lawyer, Marty Singer, told